I had just come back from the military, and I came back with an attitude that if I can go to a foreign country and fight for them to have a right, then I certainly could come back to Montgomery and fight for our black citizens here to have an equal right to education, economic, and anything else that we're entitled to.
School desegregation in the 1960s and 1970s really had not addressed segregation in higher education. All the cases involved K-12 schools. The levy-making cases here in Alabama are the most famous, of course. And in the K-12 desegregation cases had turned into what I would call head count cases, because the standard of whether vestiges of segregation still remained in the K-12 schools, according to the courts, was whether or not a school was, quote, racially identifiable. And by racially identifiable, they usually meant 90% or more black, 90% or more white. It was a head count. The burden was pretty much on black students in K-12 desegregation throughout the South, not just here in Alabama.
The lawsuit was filed in January 15th, I can remember that date, 1981. Now that was the original lawsuit. It was Knight v. James at that time. Governor James was the governor of the state of Alabama, so it was against Governor James and all of your four-year institutions. So that was the first one that was filed. What happened was the Department of Education filed a similar suit in Birmingham after that, maybe a year or two after we filed the original case here in Montgomery. So rather than litigate the same issues in two different judicial circuits, we dropped the lawsuit that I had filed, that was Knight v. James here in Montgomery. We petitioned the court to intervene in the lawsuit in Birmingham, Alabama, that the Justice Department had filed against the state of Alabama because of segregated four-year institutions. You had your white schools basically, and you had your black schools. You had very few black faculty members at your traditional white institutions. You did have some whites at your traditional black institutions, but it was segregated. There was no question. It was segregated as it came out in the court because that's the way they wanted it to be in Alabama. And so we had to prove, and it was not difficult proving that they had participated in the practice and pattern of segregation of our school system because they were segregated. And you had all type of historical documents in terms of the segregation, how it took place and things of that nature that you could present to the court. And the state of Alabama couldn't say that it didn't happen because they were a matter of legislative records, they were a matter of all the records dealing with education in the state of Alabama. So from a historical standpoint, there was no denial that Alabama State and Alabama A&M had been discriminated against. One thing that we said was in that case, and it was the fact, was when they created Alabama State and Alabama A&M, they created them for blacks. That was a part of the record. And they're supposed to be equal, created equal so that blacks would have an opportunity for an equal education as whites. One thing that we contended to the court was that they gave Alabama State a bad check. They gave Alabama A&M a bad check. When you go back and you trace the dollar amounts, the investment in the University of Alabama and Auburn and all of the traditional white institutions, it was much more than what Alabama State had received. And we were going to court saying we wanted our fair share.
Well, the first turning point was the disqualification of our black judge, U.W. Clement. Auburn and I think the State Board of Education filed motions to have him disqualified on the ground that because his children were potentially black students in the black universities, he had a conflict of interest. Think about that. What does that mean? Does that mean that only a white judge can preside over a desegregation case? It's outrageous. When they disqualified Judge Clement in 1987, and it was supposed to be assigned to another federal judge here in Alabama, we said all the white judges have connections with the white universities. They ought to be disqualified too. And after working our way through, I think, 3 or 4 different judges, finally the Court of Appeals sent us a Georgia judge, Judge Harold Murphy, who sat in Rome, Georgia. Knight versus Alabama had a number of final decisions. There were judgments that came out in 1991, 1995, 2006, and in between there were various phases of the case, a very complex case. Order that he put in his injunction was to establish endowment trusts for the 2 HBCUs, for Alabama State and Alabama A&M. And he required the state to contribute $1 million each year into an endowment trust and match any amount that the universities were able to raise on their own.
The final order was that they had segregated against Alabama State as well as Alabama A&M, and the order was to have a remedy in terms of how to correct the things that had been done in the past, knowing that you couldn't go back all of those years and make all the corrections, but trying to make certain that Alabama State would continue to exist as well as Alabama A&M. We won that case, and the court put together a committee to oversee the implementation of it. Alabama State was awarded programs, was awarded money. Alabama A&M was awarded programs and money. We were given that time also a trust for educational excellence. I think as we speak today, Alabama State has a trust for excellence probably in excess of $100 million. And I think A&M has probably about 50 or 55 million in their trust for excellence. That's something that would be there forever. To help with faculty development, to help with the academic programs at Alabama State. And when you look around the campus here at Alabama State, you see the new buildings, the new programs, the PhD programs, the graduate programs. All of those were a part of the lawsuit and the implementation. During the implementation, we had to place in the Alabama State budget a line item for Alabama State, a line item for Alabama A&M. And it was called the Knight line item. And that was the revenue for all of the new programs that were granted to Alabama State as well as to Alabama A&M. Now, the case itself was much broader than just Alabama State and Alabama A&M. A lot of people didn't realize that. It also had provisions in there where your TWIs, which were your traditional white institutions, had to make certain that they had black faculty members. And it was a reporting process that they had to prove that they were putting forth an effort to make certain that they were recruiting black faculty members and that they were getting them on their staff.